All right, so to start out, does anyone have any bills or issues they've seen in the news that are of concern to them or that they want to talk about at first?
I had
Hi,
emails
Austin.
come over.
This is Janet Haskell.
Hey, Janet.
I was looking at the bills today, and there's one HB 133,
Okay.
which is about healthcare facilities. It relates to whether visitors to the facility have to have proof of vaccination. And it's proposing that they not have to show that proof. There may be exceptions, but. And it seems to be fast tracking. So I just
Okay.
tomorrow I believe is one of the committee hearings.
All right, let me share my screen here so people can see this bill.
I can barely hear you, Austin. I don't know if it's just me.
Okay, does my sound work for other people, or am I quiet for everybody?
You sound good.
You're good for me.
Okay, must be
Okay.
something with my phone.
Yeah, so hopefully you can turn up your sound. I don't know. Sometimes
Yeah, it's as high as it can get, but I'll just listen closely.
Yeah, I'll try and talk a little louder if that helps.
Okay.
Yeah, so this is a good bill to look at. So we had COVID happen.
Yeah.
Where the healthcare facilities became very concerned about the spread of COVID, understandably.
Yeah.
And I would guess that there were some that require vaccinations for visitors. And I know that, for example, it was a sad thing for me, but when COVID hit and they shut down visitors to rest homes or recuperative homes for older people that are there, or long-term care facilities, they said that only essential people could visit those facilities. Since I'm an attorney, I was classified as essential, which made it so that I could walk into any one of these locations to do wills and trusts for people. And it was really kind of weird, honestly. They didn't get to see their kids. They didn't get to see their family, but they could see me because we were working on will and trust. So it did feel different to me. And it certainly was something that I found interesting. But yeah, but on this, should a healthcare facility be able to require proof of vaccination to a visitor, or prohibit physical contact between the visitor and the patient?
Yeah. It actually affected me, not here in Utah, but another state, when I wanted to go see my mother in an assisted living, and I couldn't get there for 3 years because I wasn't vaccinated.
Wow.
And to me, that's unacceptable.
And so this is one, it sounds like you would support this type of bill.
Yes, I do.
Saying that they can't require vaccination status of a visitor.
Yeah. I think it's proof of vaccination that they can't require.
Yeah, so the bill says here, let's see, require a visitor to show proof of vaccination or immunization status. Let's see.
So is the fact that this is moving quickly, or compared to some of the other bills I looked at, is that an indication that it's a priority, or what does that tell us?
No, I don't think it tells you much, honestly.
No.
So it came to, if you look at the status here of the bill, it came to the clerk of the House, which is usual. went to the House Rules Committee, which is the committee that gets to assign which committee the bill goes to. So they pick the topic and which committee is best suited to hear it. They sent it to the House Health and Human Services Committee. And that happened yesterday. But the committee, the Rules Committee, sent out quite a few bills yesterday. So that is something that would have been there. And so you would have a lot of bills assigned to committee yesterday or today.
Oh,
And then those
okay.
committees will schedule hearings on them. And looking at the status so far on that one, again, there's no committee hearings scheduled. Let's see, actually. Let's see, agenda, see when it's scheduled for. Thursday, January 19th. Okay, like you said, tomorrow at 2.
Yeah.
They're going to hear youth sport safety amendments, healthcare facility visitation amendments, and local health department revisions tomorrow. Out of the ones that have been assigned so far. So
how important is it to attend those meetings? I've been in the past and you get to hear concerns or, support or whatever.
generally, I'd say if there's a bill that you're really concerned about or really support, it's very wise to attend if you can, to make it so that you can at least let people know you support it, because it's a big thing if they know that people support it. If they only have people show up that don't support it and are opposed to it, they may not vote to move it on. And so I don't know if they're still doing. Okay, you can. So it says members of the public may participate in the meeting remotely by visiting the committee's webpage to access the live streaming options. And they usually, last year and the year before, they had options for you to ask to speak, and you can speak remotely. So you don't have to go up to the Capitol necessarily.
Yeah.
You can participate like you're doing here.
Okay. Yeah, I did that last year, and they were good about that. They did take comments and questions and that. Okay. Well, I'd rather be there, but if it snows.
Yeah, the Capitol's tough when it snows.
I'm in a snowy place, so I might zoom in then. Okay, thank you.
Okay, and does anyone else have any comments or feedback on HB 133?
Did Mom figure it out?
All right. So do we have any other bills that people are interested in looking at? I know someone else has spoken up. And if not, that's fine. You can just let us know as we go through if you have things that are of interest to you. So some of them, one of them that I thought was really interesting that I thought we could look at is HB 216. This is one that might be a little harder to understand without some legal background. But this bill proposes to establish a business and chancery court in Utah, and then goes through what this court will hear, kind of sets up the whole court system. And so to understand this, just real quick, I'm just going to mute everyone because we have a little bit of talking. So if you want to say something, just unmute yourself. And that's fine. So jump in at any point or put something in chat if you want to. But we have the Business and Chancery Court is what's called a court that has special expertise in business matters. And so the courts have come under fire a little bit lately. It's been not just recently, it's been over the last decade or two, where legal disputes have become incredibly complex. Some legal disputes, I should say, not all. But when you have big old intellectual property disputes, patent disputes between Microsoft and Apple, for example, they can put on evidence for 3-4 weeks straight talking about their patents and talking about how they're different or the same. It's super technical information. And it's very difficult for a jury to follow. If it's in front of a jury, it can be difficult for a judge to follow. When a judge is hired and put on the bench, they don't have to have any particular expertise in any one area. They will hear cases on divorce, on criminal law, on personal injury, real estate, wills and trusts, business disputes, non-compete agreements, loans, lending, landlord-tenant, all kinds of areas. And no judge knows all the laws. No attorney knows all of the laws. And no judge or attorney knows every industry, knows all the ins and outs of them. And so there has been situations where people have felt judges didn't understand things well enough to be able to make a good decision. And so Utah, so I guess back up a little bit more, Delaware, super small state, decided they were going to make a name for themselves by creating a specialized business court. And Delaware worked very hard to create very solid laws for businesses that were easy to predict what would happen. They got rid of tons of ambiguities. And then they created a business court for when there still was an issue to go through and address these. And Delaware's business and chancery court has become kind of renowned around the world about setting precedent, having what they consider good decisions and things, because the judges there are business minded. They understand business. They understand what's going on. And so a lot of businesses choose to incorporate in Delaware. So Delaware, for example, can charge $400 or whatever they charge for business to register there. And they have a franchise tax they charge to keep your business going in Delaware. So every year the business is incorporated there, it continues to pay a fee. A lot of businesses around the country choose to incorporate there because of the predictability that the law provides and what they feel are good decisions, good quality decisions that come out of the business court. So Delaware actually makes an incredible amount of money off of all the businesses incorporated there, just through the filing fees that they pay and the franchise tax they pay to stay in business each year. Just like exceptional amounts of money because there's so many businesses there. And I may think they joke that there's one address in Delaware that hosts over 1 million businesses at it or something, because you have to have an address to incorporate there. And so they rent an address, and there's businesses that rent addresses, and they'll house just insane amounts of companies at the same address because they're not really there. But so Utah's looked at this and said, hey, we want to do the same thing. We want to put 2 judges on it who are really specialized to make really good decisions. Start to build up this body of law that makes us a very business-friendly state, and that helps attract businesses here. This court helps attract businesses if it gains a good reputation, like Delaware's. And they're proposing in this that if a dispute is over $300,000, let's see, going down a little bit, that it can be filed in the business and chancery court. Sorry, if a business dispute, which involves contractual disputes, is an amount over $300,000 at issue, they can file it in the business and chancery court. Now, there's not a jury available in the business and chancery court because they feel that juries wouldn't understand these issues well enough to be there, is what I assume. They don't say that, but that's my assumption. And obviously there's a constitutional right to a jury trial. And so if a side requests a jury, then the case gets kicked out and sent to a normal court where a jury can be convened. So currently people don't lose the right to a jury trial because they could request it and get kicked out of this court. But these are the types of things that this court's going to hear. Has to have the $300,000, and then you can see the and. So these other things, one of these other things have to be satisfied, has to involve a claim arising from one of these things. And you can come down here and see it's just one of the things that's necessary because it says or at the end of the list that goes through S. So breach of contract claims, fiduciary duty claims, governance of a business organization, sell merger, sell of the business, dispute over indemnity, liability, tortious interference with the business, a bunch of these different things, intellectual property. And so it's a debate that's gone on for a while about whether courts should become specialized or whether it's better to have your dispute heard in front of a judge that's well-rounded in many areas of law, that's heard a lot of disputes and sees a lot of disputes. And so we continue to have the discussion about, should there be a criminal court that only hears criminal law cases? Should there be family law courts that only hear family law disputes? Currently, Utah has what they call magistrate judges who will only hear family law matters. They make recommendations up to the district court judges, the typical general judges, who then can sign off on things. But they do have that kind of specialized unit under those judges. This would be a specialized unit outside the district court. But in some ways, it streamlines things, makes it more efficient because they know what they're doing. They've heard it all before. But there are some concerns about it as well, in the sense that some people feel you get better decisions overall if people have a more well-rounded approach and look at more than just the divorce in front of them or the criminal allegation in front of them, or the business dispute in front of them. And so I'm curious if any of you have any opinions about whether it's healthy, not healthy for Utah to start specializing its courts out, especially to appeal to high money interests, to kind of try and attract those through that mechanism.
Hey, Austin.
Yep.
My gut reaction immediately is you say they're going to put 2 judges over this court. My first reaction is that's a few amount of people to have a very heavy hand in business in Utah. If you have only 2 judges, that puts a lot of power in a small amount of hands. I don't know. That's my first thought.
Yeah, it's a good thought. Specialized courts tend to have far fewer judges. Currently in Utah, if you have a dispute, you file in the county and you get randomly assigned to a judge in the county. Different counties have different amounts of judges, but if it's in Salt Lake County, there's quite a few judges. And it makes it so you can't, it makes it hard to get to know the judge super well or become buddies with them because there's so many of them. But yeah, as an attorney, if you're in just front of 2 and you want to be a good business attorney, you're never going to want to tick one of those 2 judges off. You'll work pretty hard to stay on their good side, or else you won't be very effective in those courts.
So would this be 2 judges for the whole state?
Yes.
Okay.
Yeah, that's where it would start. I assume if their workload grows bigger, it would expand. But I don't even think in Delaware it's a crazy number of judges. I'm not sure though. But yeah, it would just depend on the workload, but it starts out with 2. But there's that aspect about, should we have judges that understand patents if you're going to hear a patent dispute? Yeah, maybe. Or should it be the lawyer's obligation to break things down to the level that anybody can understand? Because the founders did feel juries were a very critical check and balance on the government, check and balance on laws, check and balance on just what's reasonable, what's not. One of the concerns with specializing is that people lose touch with what's really reasonable or what works. And just as an example, you can have, you can go to a healthcare professional, for example, and say, hey, what should we do to stop COVID? And they say, well, shut the country down. And while that may help with COVID, may not, people have different opinions on that. It doesn't take into consideration all the other impacts and fallout from that decision. The health experts aren't set up to understand what takes place and all the other, the dominoes that fall and things that follow. And so judges that are well-rounded, in theory, may be able to understand those impacts better, see things further than someone that's specialized in just one area. But they also may miss things. So currently Utah is not making this court mandatory. Again, people can opt for a jury trial and get out of it if they want to, but they can opt to use it if they want to. But another concern with it is, should a state be focused on structuring its laws and services it provides in a way that helps the state make money? Now, should the government be involved in the business of money? Should it not? Because Delaware can make a lot of money off these courts and the disputes coming there. And is that a healthy thing for courts to be pursuing? Does that create a conflict of interest? What do you think about that?
Well, Austin, the thing that I find interesting is that apparently businesses really like this since
Some do.
they're flocking to Delaware, even though they don't exist in Delaware, they're licensing there. That kind of tells me that on the business end, they really feel like these courts are going to rule in their favor most of the time.
Yes, but a lot of these disputes are business to business disputes. The reason that they value it is because businesses hate unpredictability. And Delaware has created a very strong system of law that's become very predictable. The outcome's predictable. So if a business does X, they know either they're going to win or they're going to lose. So yes, in a way, they know they're going to win more, but it gives them very clear guidelines. Currently, especially in Utah, our case law is not crazy developed because honestly, in Utah, we don't sue anywhere near as much as other states do. And so there's still a lot of holes. For example, I'm in a non-compete case right now, defending some people against with some non-compete agreement allegations. And in Utah, we've got a handful of cases on it that have been appealed, but most people don't have the money to fight these things extensively far, and there's not a lot of precedent. So it's still unpredictable to an extent to the businesses about what's enforceable, what's not. And a lot of businesses choose to say, well, I want predictability. Give me the very safe line. I want to know what the law is, what it isn't, and I'll go to the state where it's very predictable. But to your point, they do value that. And so again, businesses choose that.
Then your question earlier, I'm sorry, I kind of sidestepped that, but should the state be involved in generating the fees? That question to me seems like if they're creating this court, I mean, I don't know that they are, but if they're creating this court just because they feel like they can make money on it, I'm not sure that's a good premise for that. But if they feel like if it's of value, that's a different story. But
yeah, and we don't know, all the reasons behind it. It's just anyone that looks at Delaware, it's very clear that they have, they do generate a lot of revenue off of it, off of their strong precedent, you could say. And so when you look at Utah, looking at the possibility, whether or not this current sponsor, whether or not any current legislative reps are thinking about money, I think that conversation will come up at some point in the future because of Delaware's precedent on it.
Austin, how do they make fees? I mean, how do they raise money on this? If it were, obviously it's part of the program. So how does the government make money?
So it's indirect in that the court's not charging anything extra to be there. They're not making money off of the disputes that are there directly. But as these experts that they call them, these expert judges make these wise decisions and make good precedent, that attracts businesses to form in Utah. And so in order to form a business in a state, you have registration fees, and then you have ongoing fees to keep that business in place. And if a business is registered here, the state has the option of imposing taxes, not imposing taxes, doing different things. Currently, Utah actually just recently lowered the business filing fee. It used to be $70 and they lowered it to $54. and they lowered the renewal fee, I think, from 25 to 18 each year. So Utah currently doesn't make a lot of money, and they also don't charge a franchise tax, which is a tax based on your existence as a business. You pay it each year, or you pay it based on income. States divvied up differently, but some states make an incredible amount of money on that, including Delaware. And so what the business court does is it starts to create a very favorable environment to attract businesses to Utah. As businesses come and they form here and do things here, the state then has the ability to adjust those fees, to set taxes in place, other things. But some people say, like in Delaware, it's smart in the sense that the Delaware residents don't have to pay these fees. They're making money off of people outside the state for a lot of what they do. And it really helps offset a lot of their fees in Delaware. And so it is something to say, should the state be wise and say, hey, let's collect some more money from out of state and make a place where people want to be. But again, you talk about, is there a conflict of interest? Because then what happens? Do these judges rule in what's just and appropriate? Or to Don's kind of question, do they start to rule in favor of what attracts the businesses? What helps them win? So for example, if you sign anything or do anything with Microsoft, they have an arbitration agreement that you sign, and a lot of these big companies do, and you go in front of arbitrators that work consistently on disputes for Microsoft or others, big companies. And at some point, if you're not delivering favorable enough results fairly consistently, they're probably not going to continue to hire you. And so again, the question is, does it create a conflict of interest that we're concerned about? Are we not concerned about it? To let these courts try and create this precedent, try and be this, this leading body? Or do we want those to keep that general judges who are concerned about the state as a whole, who see everyone and everything? Because the business judges aren't going to know about the effects of divorce and criminal law and all the sad things that happen to people. They're just going to be involved in the high-end business disputes, not see the other things. And that's one to think about, whether you like the idea of these becoming more specialized, or you'd prefer to keep it more general. But over time, if this bill does pass and Utah establishes this court, I think that it would start to become more and more where, these courts become more common. We start to get the different specialized units broken up. And again, that could be good, and it could have some negative effects as well. So I've always been curious about how to help balance those. But let me know if you have any other thoughts or comments on the business and chancery courts. Let's see. And then are there any other questions people have?
I was going to say one I thought that I liked was House Bill 163. And it allows for you to dress as you feel is appropriate in sports attire, which I thought was an interesting one to bring up and have sponsored.
All right, so thanks for bringing this one up. Let's see. So they're allowing students to conceal parts of their body to put something under their uniform. So this, I think, came to light, this issue. I think some gymnasts in Germany or somewhere back in Europe wanted to wear something that was not so revealing. And I think they got kicked off their team or punished for it. So it kind of created this issue. But I do know that, I wrestled, for example. I was never super comfortable in that wrestling gear. And we'd wear it to wrestle, and then as soon as we could after, we put our warm-up clothes back on. And so curious what you think about this. Does this create an issue for sports? Is it a good thing, bad thing? If we say that the students can wear something underneath the uniform.
I think in the bill, I think it's in here, it says that if they require a certain color or whatever, then the schools have to provide it to whatever standard the student wants. And I think that could be a little hard to get it specially made or tailored for one student, but the same vein, maybe it will just allow them to say, hey, you can just wear a long sleeve leotard if you want, or whatever. So it's not as expensive for them to say or whatever. I don't know what yeah.
Okay. So you're thinking maybe it goes a little bit too far with some of that protection?
I just think it could be hard for them to accommodate potentially if they have to have like something specially tailored. So I don't know if it goes too far, but it might just make it so that they're not so strict if it's not exactly the same, because maybe they can't afford to specifically tailor it.
Okay. Those are good thoughts. Anyone else have any thoughts on this one?
So I'm just trying to understand. So this is in situations like, for example, if maybe a student is, Muslim and needs to wear like a head, like, I'm not quite sure. Is there a law barring that you can't? I'm just not quite sure what this is addressing.
Yeah, so that's a good question. There's not a law that says you can't, but many teams say you have to wear the uniform, can't change it, or you can't be on the team. And so if you think about things like volleyball that have very short shorts that some students may be opposed to,
Sure.
maybe their religion wants them to wear longer shorts, or gymnastics is another example, swimming, if you're wearing a Speedo, can you wear something else if that's part of your religious beliefs? If you're a basketball player, can you wear something over your hair? Can you not? These issues have started to crop up in sports where people are saying, I'm not comfortable with uniform. Either it's my religion, or I want to cover up some more based on my moral beliefs. It says religious or moral beliefs. And then the sports teams say, no, you can't do that because you got to look like everyone else, be a part of the team. And so individual teams and schools or associations have placed restrictions on what people can or can't change with their uniforms. And so this law is taking away the ability for a team, a local unit, a school, to say what you can or can't do, to say, no, the students need some freedom to be able to wear a swimsuit that covers more, or to wear, longer shorts or the headgear that they need to fit their religion, so long as it's not, let's see, does it say anything about so long as it doesn't interfere with the sport? I'm trying to see if they say something like that.
So could this also go the other way? I mean, could someone say, well, I want to wear a bikini to play basketball in?
That's a good question. So it says that they can wear religious clothing with the athletic uniform, or wearing clothing under or with, but not substantially covering the athletic uniform, to cover or conceal parts of the student's body. So it's not written to go the other way, where they could wear less. The team could still say they have to wear less, or the team could still say they have to wear at least the uniform and not something less, based on how it's written currently.
Okay.
And then Austin, going back to your example of wrestling, I wouldn't be very comfortable wrestling someone who had a t-shirt on. I mean, we practice in t-shirts, but if my hand got caught in someone's sleeve, it could injure me pretty badly.
Yep.
And I think there's an argument against putting too much clothing on in certain sports, because it would then be potentially, I guess potentially dangerous. Not very many cases, but in some cases.
Yeah, and I think that's one thing I'm looking at here where I'm going, they don't have a provision about it interfering with the sport itself. Because I think if it interferes with the sport itself, they should still be able to say no.
Yeah,
if it makes it
I
so
agree.
you can't play the sport or do it safely. Because for example, if you're playing basketball and someone's head covering or something is causing interference or getting in the way or doing something, I don't think that's necessarily fair. And like you say, if I put on a t-shirt, well, we have those wrestling uniforms. They're not comfortable to be seen in, but they are necessary because we're wrestling and it's to help prevent injury and help prevent those from getting, pulled and different things happening. And so that is something that
interfering in the sport may be hard to define, in that if you look at something like swimming or track and field, the idea is the tight clothing, the less clothing means you go faster. So are you interfering with your team if you decide that you want to wear baggier clothes when you run? It may be a difficult definition there. I'm not sure. It seems a hard thing to define, interfering with the sport.
Yeah, I'd agree. Yeah, maybe it'd have to be focused on safety if it creates a safety issue or limits other people's ability to participate as well. But yeah, to me, it seems like this may need some more detail to it. I like it personally. I like it in principle because I think there's some teams or some uniforms that are just pretty ridiculous, and I think there's
Yeah.
nothing wrong with
It's
some
not
additional,
necessary. Yeah.
yeah, some additional clothing with it. But like you do say, there's some interesting points brought up here about, and the funny thing about swimming now is they've created a swimsuit material that's supposedly faster than skin. And so a lot of the swimsuits are moving to full body swimsuits because they're supposedly faster than skin. And so people are starting to wear those. But, I don't know. Again, it's a funny thing how that goes. But yeah, this is a real interesting one. Appreciate you bringing it up.
I have a big question.
Okay.
On another bill. It is the Utah Fits All.
Yep.
Scholarship and the Hope Scholarship.
Yep.
I think that one specifically. Okay, so my girls go to a private school, and we're in this huge debate over whether we should support that, because there's this fear that if we take money from the government and then give it to our school, that they could at some point require the private school to follow government curriculum mandates.
Yep.
And even though it says right now that it's not going to, could they change that?
Absolutely. So one very important thing to understand about anything written here, you see all these changes proposed, these underlines, these crossouts.
Mm-hmm.
All that they have to do is cross something out and underline it. There's nothing in statute that's ever set in stone. If they say we can't change this, they can change it, because statutes by definition are changeable by the legislature anytime. People in the state of Utah can do a ballot initiative and change any statute. The only thing that gets locked in are constitutional things. So if we want to lock something in place, a protection or something, it has to be in the Constitution. Even then, constitutions can be amended, but it's much harder. But statutes can be changed at any time. They can call a special session and change it in a month. They can do whatever. So the bill can say whatever.
Yeah.
But anything can be crossed out and new stuff put in at any point.
So what would you say about that? Like, I mean, obviously there's a lot of parents that would love some financial relief. And so, yeah, right now it says that it doesn't have any impact on the school's curriculums or philosophy. But do you go down that slippery slope?
So it's a great question. If you asked a founding father, my opinion is the founding fathers would say absolutely not. They say recognize that when power exists, people will seek it. And they were always a fan of putting checks and balances in place. So they're going to say, if you're going to do something like this, you need to have actual checks and balances. Language in a statute is not a check and balance. There has to be other things created to prevent those slippery slopes from happening. Now, some of these reps, I've talked personally with reps sponsoring this, had very long meetings with them about this bill. And they feel that the bill gives potential for good things to happen. They say it doesn't have to be bad. Doesn't mean we'll regulate it bad. You know, you're not putting any faith in us. Good things can come. And it's certainly true. You know, good things can come. But if you just think about, let's say that money is being given by the government with no strings attached, and it becomes known in the public that people were, you know, these private schools were taking money and the kids played Pokemon all day or watched Magic School Bus all day or something like that. And the schools made a ton of money. The public's going to be up in arms about that and say, hey, you have to do something about this government because this is our money going to them. It's a waste of money. Tighten it up. And at that point, I don't see how they don't come in and regulate it more, because whenever we have issues like that, society demands more regulation. More regulations start to happen. We know there's going to be people that misuse the funds, abuse the funds, make a profit off of it, whatever. And these things will happen. But if you look at just the bill as written, it's fascinating when it talks about, oh, we're not going to regulate. Because just from the outset, they actually incorporate federal law into this bill to say that if you want to be eligible to get money, you have to comply with federal law. Now, this particular federal law talks about race discrimination. So it says you won't discriminate on the basis of race. But what this does is it now opens this any regulation here up. Since Utah says you have to comply with this statute, that's essentially handing the federal government something and saying, all you have to do is modify this, put in any requirement you want, and then that automatically flows down to every private school in the state because of this causal link here. Where to continue getting money, they'd have to comply with whatever the Fed said in this provision. So to answer the question, from my perspective, if people want safeguards, they need to create those checks and balances. It needs to be an actual system in place that has competing interests, kind of like the founding fathers set up the government with competing interests, to really have some strong checks and balances in place. But from my perspective, this bill doesn't create any checks and balances because, well, I'd say lasting checks and balances, because any of them can be overridden at any point, including by the federal government.
Wow. Okay.
And so then it is just a faith-based thing of we're putting our faith in the elected officials in years to come and our faith in people to take the funds and do good things with them.
Mm-hmm.
Austin, just as a side note, I heard this is secondhand, so I can't be positive, but I heard of a private school that will refuse to take those funds if they become available because they don't want to become subject to anything like this in the future.
Yes, there will be some that refuse to take the funds, and the end course of almost everyone that refuses to take the funds is that they go out of business. Because as these grow, you can't compete with the other groups because you charge more and things. And we've seen, you can look at a fair amount of history when money flows to private schools from the government. The private schools that don't take it go out of business because they can't compete. So they'll make a valiant effort, but when you're trying to compete against subsidized education, it's very, very difficult. Because you have to have people that aren't taking the money too, to go there. So HB 215 is of high concern to me personally. And I think it is something we should be wise about.
So this bill is actually going to committee tomorrow, to the education committee tomorrow at 2:00.
Okay, good to know.
Okay.
So it's room 30 in the house, I think it was. I can't remember. But it will be
Let's see
there.
here.
Yeah, room 30 in the House building. And the bill sponsor is the chair of the committee.
Oh.
So kind of funny, but not funny.
Can you go, Austin?
Yeah. Sorry, what was that?
Can you go and just say what you just said?
Yeah, my week has been insane. This has been a very busy week, unfortunately.
I'll try to make that though and see if I can try and articulate what you just described.
And if it makes you feel any better, I have had very long meetings with the bill sponsor on the Senate side and shared concerns, gone through things, tried very hard. And so this isn't something I've sat idly by on. I also have a blog post I've written on it that explains a lot of concerns with it. Goes through some history of similar government actions in the past, quotes some Supreme Court justices that warned about some things with this type of legislation. So those are, yeah, I have done a lot. I doubt I'll be at the committee hearing tomorrow, unfortunately, just because my work doesn't always allow that as an attorney. But I would love it if some of you speak up there for sure.
Yeah, thank you for that knowledge. I was totally, in a quandary about that one for sure.
Yeah,
This bill has a lot of support. I'm getting marketing materials on it, so they must be well funded whoever is promoting this.
They are well funded. There's a lot of money supporting this, and they've been working, to my knowledge, in the state for 2 years trying to get a go of it. They've got websites, they've got all kinds of things out. Libertas Institute backs it, and there is a lot of money been being put into getting this passed. And so
that's interesting.
One other thing though, just real quick on this one, I should show you, since we're here talking about bills, but we should talk about law a little bit. This bill, I think, the bill's doing two things. It is increasing teacher salaries, and it is creating this school choice system in Utah. And the Utah Constitution has a provision that says that right here, this is in the Utah Constitution. Except general appropriation bills, so general bills spending money, because they can kind of appropriate things generally to a lot of different places, and bills for the codification and general revision of laws. And I can show you one of those where they go through and they're updating numbering on tons of laws or something. It says no bill shall be passed containing more than one subject, which shall be clearly expressed in its title. And so with this bill, if we go back here, you look at the title, Funding for Teacher Salaries and Optional Educational Opportunities. I think they're trying to fit this in to either one subject of funding or to general appropriations, because this very much has two subjects in it. It has teacher salary increases and then optional education opportunities. And this is expressly to make it hard for the UEA, because the UEA is very opposed to the optional educational opportunities and the way it's written here. You know, I don't think the UEA is opposed to people getting education from other sources. They're opposed to using income tax money that's allotted to education to fund private and
Wow.
homeschool situations. So they put in the bill that we're going to increase teacher salaries if this passes, to kind of force this quandary. But to me, it could be a violation of the Utah Constitution. And so it is one that's interesting. And then I guess one other just quick side note. We're talking about violations of the Utah Constitution. Go on down towards the end. Let's see if we can find it. Went a little too far. Let's see. Utah Fits All bill talks about, say, if any provision of this part is the subject of a state or federal constitutional challenge in a state court, scholarship students and scholarship students' parents may intervene as a matter of right to defend the program's constitutionality. I've never seen the state give citizens the ability to intervene and defend a constitutional challenge before. But this makes it much more difficult for an individual or group to sue and try and get this overturned constitutionally. Because instead of being just against the AG's office, which you would normally be against if you sued to say something was unconstitutional, you can now have all kinds of people join the lawsuit with their own attorneys, their own arguments, and just a whole host of things to respond to, greatly increase your costs and burden in carrying that. So super interesting what they put in there. And it kind of makes you feel like they anticipate that it is potentially unconstitutional and pushing the boundaries, but who knows why
So
they have that.
Austin, is it the teachers union that's funding it, or who's funding this bill?
The school choice bill, if it's all bill. I don't personally know. I know there's a lot of theories out there. You can look around, people will share all kinds of theories about who it is or what it is. I don't personally know. So
now it looks like it could be the union, the teachers union, because it includes a teacher's salary on the bill.
Yeah, so well, they are still very opposed to this bill. They've actually come out and said it's not proper to try and tie these two together. We're still very opposed to this school voucher type legislation. So no, they're still very opposed to it. They don't want this to go through because it's meant to create competition with public school.
Okay.
Which makes it harder for them.
Yeah.
Yeah, so those are some good questions.
Something
Comments.
too is if you can't make the session, it's really helpful to email the committee before tomorrow's meeting about your concerns. And then if it passes committee, then it has to hit each individual rep and Senate rep and stuff. So
yeah, so if you're on the bill, you click on the House Education Committee, you can see here's the committee information, all the people involved in it. So if you want their contact information, you can click on someone and it gives you their email, and you can email the committee, tell them how you feel about it. And these people are the ones that vote on it initially tomorrow. They need a majority vote to get it out of committee and to get it to the House floor to be heard. If that happens and the House votes to approve it, it then goes to a Senate committee. And then that Senate committee has to have a majority move it out as well. And then the Senate has to vote on it as a majority. But yes, in committee is the easiest place to address it because it's the fewest number of people to try and contact.
yeah.
But this is how to get that information. Again, for any bill, once it's assigned to committee, you can click on it, follow that information back. So Utah tries, I do like how well Utah tries to connect us to things to keep it pretty simple to follow. One I wanted to bring up real quick before we finish, if that's all right, is HB 219. There's a lot of firearms bills this time around. I think that gun control or less gun control or more gun control is a very hot topic. And we have this bill that is saying, So it goes through with kind of these findings they talk about. So it's a lot of talk about our constitutional rights, things that Utah gets to do. It's kind of an assertion of states' rights. But it goes down, and the gist of the law is down here, which says in 1 and 2 that a law enforcement officer, state employee, or employee of a political subdivision, which is like a county, school district, something like that, is prohibited from implementing, enforcing, assisting, or cooperating in the enforcement of a federal regulation on firearms, firearm accessories, or ammunition. And they can't expend public funds or public resources to enforce federal gun regulations. So if this bill takes effect, the police in Utah would not be able to enforce federal laws related to firearms. And feds have quite a few laws on firearms, banning machine guns, ammunition types, strengths, because there are some very powerful weapons in existence. And so a number of those are prohibited from being owned. They also have regulations that obviously regulate other things. But this just bans all federal regulations, or it bans enforcement by the state of all federal regulations. Now, the FBI could still come in and arrest somebody, but they'd have to do it on their own without the police involved. And so it's again, Utah's, at least this rep, her proposal is, let's make Utah a state that says no to the federal government regulating firearms, because that's our domain. But I don't think Utah has very many regulations on firearms in place. So curious to hear thoughts on this bill, this proposal, if you think it's a good idea or a bad idea.
So this is safeguarding like future regulation, or like Biden just came out with I think he came out with some kind of prohibition on some certain type of a piece of a ammunition. I mean, is it a safeguard from federal overreach? Is that what I'm understanding?
So not exactly. The feds have their laws, they have their things that they do. They have quite a few laws on the books related to guns, manufacturers, all kinds of things. Those exist. Future ones will be passed as well. But Utah is saying, we're not going to allow our state officers, so all the police here in the state, to do anything to enforce an existing federal law or a future federal law.
That's
and
awesome.
so for example, we have federal laws, I think, that ban machine guns generally with citizens. Utah would stop enforcing that. Now, again, the FBI, a federal agent, could come in and still enforce it, because Utah can't stop a federal agent from enforcing it. But in general, the federal government relies on states to enforce the federal laws. We don't have a federal police force yet. The FBI is the closest, but they're nowhere near a police force. There's not enough of them to be policed throughout the whole US. And so drug laws, for example, gun laws, a number of these laws, immigration laws, these are all enforced by local police for the most part.
So this is just more protection for the Second Amendment.
That is what it makes that proposal. It says that's what we're doing. It says that's their intent, is to take states' rights with the Second Amendment. But I think the question to ask with it is, are there no federal regulations we should enforce and just say no to all of them? And if Utah elects to do this, what happens? What's the fallout? What's the potential fallout that happens to Utah, to other states, to the country, if we stop enforcing federal laws? Because there are states that don't enforce immigration laws anymore, and they say we're a sanctuary city, so come here if you're illegal. We're not going to enforce this. We're not going to do anything about it. And then you have people saying, oh, drug laws, we don't care about those. We're going to stop enforcing drug laws. So feds, if you want to come arrest someone, go for it, but we're not going to enforce them. And so states have become drug havens or immigration havens, and now we have gun regulation type havens where we're not going to enforce it. And the question is, once the states stop enforcing federal law, whether they're on one side of the political spectrum or the other side of the political spectrum, what happens to the whole system? My concern is that it leaves the federal government with two choices. Maybe there's some others kind of in between. I guess three choices. One is do nothing, let the states just, do their thing, and kind of every state start enforcing or not enforcing federal laws, which creates quite a ruckus among the states. Makes it hard for people to know what to expect or not to expect. Businesses have an especially hard time. Or the federal government can say, okay, you're not going to enforce it, we will. They create their own police force if the states no longer enforce federal law. And if enough states stop enforcing federal law and the federal government creates their own police force, that's a scenario I would be very worried about, to have federal police roaming our neighborhoods. But a third option would be to start to regulate things through funding, like they have been in a lot of ways. They can cut off funding to a lot of programs and a lot of things if places won't follow certain laws or do certain things, which maybe is a good thing. But for example, if they said, oh, you're not going to enforce gun laws, well, we're going to stop funding your roads. I don't think Utah's in a place to pick up the tab for, keeping I-15 and 215 and I-80 and stuff up to date.
But in the
and
case
so-
of Second Amendment, isn't that a constitutional right that is constantly being encroached upon? I mean,
well, it
it's not
depends.
constitutional right to, have your roads or whatever. The Second Amendment is a fundamental right of citizens that specifically says not to be infringed, right? And the federal government seems like they're constantly trying, especially factions of it, are constantly trying to infringe upon it. And so would this just safeguard that constitutional right in Utah?
No, because the laws would still be in existence. People could still go to jail if they're arrested by a federal agent. It would just make it so there's less chance of enforcement. But the constitutional right, so one of the things to understand with, shall not be infringed. For example, the First Amendment says the freedom of speech shall not be abridged. Congress shall pass no law abridging the freedom of speech. We have an incredible number of laws regulating speech in America. And that the courts go through and they've determined that there's no right that's absolute in the Constitution. Every right can be overridden at some point. And just as an example with the right to bear arms, we don't have the right to have machine guns. We don't have the right to have bazookas, to have grenades. We don't have the right to have nuclear weapons, tanks, missiles. And that's a right that's been, that we don't have as people, and that's been gone for a long time. And so the right to bear arms, that shall not be infringed. What's happening in the nation is there's this argument over where the line's going to be drawn. The Supreme Court's come down very strongly and said, you can have guns for self-defense. States can't touch that. And they've come down very, very strongly on that. But we have a battle over the line. It's kind of like the battle over abortion. Where's the line? Where's the line? And so right now it's all being tested. Where's the line? What are the courts going to allow? What aren't they going to allow? Because we have accepted as a society that there is a line. We've accepted that people shouldn't have missile launchers and tanks and grenades and things. And so the Second Amendment right that was being battled is where's the line? But Janet, you have your hand up.
Yes, sorry, Austin.
No worries.
I was just thinking, doesn't it put the burden on the states then to, toughen up their own laws so that they're not dependent on the federal laws that we think are relevant? I mean, couldn't they do that as a state? And because truly, I think the majority of people right now do not trust the federal government. Okay, let's just say it.
Yeah.
There is no trust left.
Mhm.
Now, is there any trust in the state government, so, you know. But
maybe.
I do wonder if we could bolster the state laws, then we can move away from the government federal on things we don't like. And they certainly are taking more and more control.
So honestly, most of the contentious gun laws in existence right now are passed at state levels. And most of the fights are happening with state laws. The feds do have some laws, again, things like machine guns, that kind of stuff. And they have laws on selling, buying, a couple things. Now, I don't know all the federal laws well enough to be able to say what exactly might happen if we don't enforce them or do. But to your point, can Utah pass laws on guns? Absolutely. Is Utah passing many laws regulating guns? I haven't really seen too many. There's a lot of bills this session going through different things, including even there's one that exempts school employees from paying the fee for a concealed permit. So they get to save $20, but then the education fund pays for those. It doesn't mean they get to bring them into schools as a result of that. It just means they don't have to pay for their permit fee. But Utah generally is opposed to too much in the way of gun regulation. But as a society, I think we often miss the bigger picture of, one, we have accepted the notion that there is a line somewhere. For example, no matter how much I believe in the Second Amendment, I don't want every citizen in the United States to have a nuclear bomb at their disposal. And we have this system now where weaponry and all that has become so powerful that we have to trust the government with it somehow. But it goes back to, I think, the same principle with the school choice bill. Are we actively working to create a strong system of checks and balances, or to regulate these things, to say, how do we keep the government in check with the firepower it has without giving that same firepower to every citizen? And to your point, states should have a lot of say in that. They do have a lot of say in that still. States pass very many laws, and California passed a law, again, states' rights thing. They said, hey, states' rights, we're going to do this. They followed Texas's lead. Texas passed a law that said we want to stop abortions in the state. And so we're going to pass a law that says any Texan can sue anybody that provides an abortion. And so California looked at that and said, oh, that's what you're going to do, huh? Well, we'll do the same with guns. So if you're ever shot by a gun, you or your family can sue the gun manufacturer. Just hands down if you're ever shot by them. And so there is this debate now where the states are coming at war with these issues, this cohesiveness falling apart in America as we start to assert the states' rights. And so I see, from a big picture perspective, I see concern to say we need to be careful about how we approach these issues, because if it's too extreme in the way that we do it, we can create backlash, create a lot of unexpected consequences. And for example, yeah, Utah can pass this and say we're not going to put in funds to enforce gun laws, and maybe that's fine for 5 years, 10 years, I don't know. But as more states start to follow that lead, at some point it leaves the federal government with the choice of saying, well, we have the power to tax, we'll institute a police force ourselves since you guys don't do it. And then at that point, the states' rights argument is greatly reduced when there's federal police in every state. But we have to understand that everything we do in law creates external consequences and factors. Things happen. And I view this trend, the states' rights trend, where they say, oh, assert your rights and just buck the system, get out of it. I go, that's not how America works. And that starts to degrade the system overall, which is going to lead to either system collapsing because the states all start doing their own thing, or the federal government cracking down much harder. And the federal government during the Civil War cracked down harder. We had a crazy war, a lot of bloodshed. And so it is one, again, where my approach is, let's be wise. I think that there are ways to assert states' rights without completely bucking the system. And this is one where I personally worry that we're setting a very bad precedent that's going to be used with liberal movements, conservative movements. Everyone's going to start to use it. It's going to fracture the country. and it will result in federal government losing its power, which usually they don't allow, or they're going to really clamp down and take more of it. But maybe I'm too pessimistic. Yeah,
It
these are just
reminds me
concerns I
of-
share.
Reminds me of when kids ask one parent or the other parent based upon who they think will allow or enforce something.
Yeah. So that one was an interesting bill as well.
Complicated.
It is, and there's a lot of complicated issues to look at, you know, because again, it may not lead to where I'm concerned about. That may never happen. But that is something that I see external factor with this. So, but we went a little bit over today. So thanks for hanging in there. We'll reconvene on Tuesday. If you have things you want to talk about in the meantime, feel free to email. Or if you want to join the Microsoft Teams discussion, we'll get some emails out on that soon. I'm a little bit behind. This week has turned crazy with a lot of unexpected work. But we'll get that out. But yeah, we'll try and keep the conversation going. Love to see people involved. Appreciate each of you. And really encourage you to reach out to reps again in support or opposition to anything that you're concerned about or support. It doesn't hurt my feelings if you disagree with me. I think it's good if we disagree on things.
This
And
is
so,
hugely helpful. Thank you so much.
Yes,
Yeah, no
thanks,
problem.
Austin.
Thanks for joining.
Thank you so much.
Okay,
have-
we'll talk to you guys next week.